Thank you, Mr. Chairman. We're back again considering legislation that would curtail women's reproductive rights. I understand how personally important this is to some of my colleagues, and they are certainly entitled to their beliefs. But the many Americans who see the world very differently, including millions of women who value their personal autonomy and their personal liberty, can be forgiven if this looks like just another battle in the Republican war on women. I accept that on this one we are going to have to agree to disagree. In this case, my colleagues appear, through the operation of the criminal code, to be trying to settle a scientific question on which there is no consensus within the field. That is an exercise of raw political power, not of dispassionate fact-finding. And of course, the exercise of political power doesn't alter scientific fact. Some of the views we are going to hear today are in fact viewed by many in the field as outliers, not as mainstream scientific thought. The fact that the majority has allowed 3 individuals to purport to represent this clearly established science, views that are clearly a marginal view in the scientific community, will create a false and misleading record. The fact that the minority has been limited to 1 witness only demonstrates just what a farce these hearings are. Yes, I know we could have invited our own medical and scientific expert, but that would have been at the expense of hearing from an actual woman who can provide a real-world look at the impact this legislation will have on real families. I know we could have invited a delegate from the District of Columbia, the only member of this body elected to represent the only Americans who would be directly affected by this bill, but that would have to be at the expense of hearing either from a person with real experience in this area or from a medical expert and a scientific expert with more mainstream views. The exclusion of Delegate Norton, who is relegated to sitting in the audience today, and I want to welcome her and apologize for the rudeness my Republican colleagues are showing a colleague by refusing to allow her to be heard, is yet another example of that abuse of power. Yes, the Constitution gives Congress plenary power over the district, something that we can and should remedy and have remedied in the District of Columbia Governance Act, but are ignoring today. But just because we have the power to impose our will on people who have no voice does not make it right or moral. As I have said in the past, never in my 20 years as a member of this body have I seen a colleague treated so contemptuously. The gentlewoman from the District of Columbia is a member of this body, and the people she represents are tax-paying American citizens who serve in our military, respond when one of us has an emergency requiring police, fire, or EMT services, and serve as congressional staff without whom we could not do our work. And yet this committee cannot be bothered to take 5 minutes to hear our colleague who will not be permitted to vote on this bill. The District of Columbia is not a colony. It is part of the United States, and its people are entitled to be treated with the same respect that we demand for the people we represent, and it is unconscionable that she is not permitted to testify other than as the one minority witness. I ask unanimous consent to place the gentlewoman's statement in the record.
Without objection.
Thank you. I'm not going to sit here and debate the question of fetal pain, except to note that even Dr. Anand, who was cited in the majority's witness testimony and hearing memo, and who was called by the majority to testify before this subcommittee in 2005, told us, and I quote, "I think the evidence for and against fetal pain is very uncertain at the present time. There is consensus in the medical and scientific research community that there is no possibility of pain or pain perception in the first trimester. There is uncertainty in the second trimester," unquote. The Journal of the American Medical Association concluded that, quote, "Evidence regarding the capacity for fetal pain is limited, but indicates that fetal perception of pain is unlikely before the third trimester." The Royal Academy of Obstetricians and Gynecologists concluded, quote, "It can be concluded that the fetus cannot experience pain in any sense prior to 24 weeks gestation," close quote. Are we really going to take sides in this scientific debate by jailing and bankrupting people who don't agree or actually agree with the majority in the scientific community? Because that is what this bill would do. Similarly, the claim that an abortion is never necessary to protect a woman's health is simply not one that is widely held in the medical profession. And the idea that we should be enshrining these marginal views into the criminal code defies reason. There are many difficult issues that we should deal with and deal with in a more serious and exhaustive manner. But I guess if you got the votes and the Constitution gives you imperial powers, what the heck? And one additional problem with this bill. The bill is facially unconstitutional. The Supreme Court has told us in many cases that we have no authority to ban abortion in the second trimester, e.g. 20 weeks, and we have no authority to ban abortion without a health exception, not just a life exception for the mother, which this bill does. I find it deeply disturbing that when it comes to issues like this, some people think there is nothing wrong with making families in crisis have the courage of legislators' convictions. That is just wrong. We hear a lot of rhetoric about freedom, but here we are telling women they have no freedom to make their own decisions. We will make their decisions for them because we know the morality, we know the right, we know the religion, and to heck with what they think. And to heck with what they believe, to heck with what their religion tells them. That's wrong. Mr. Chairman, I yield back the balance of my time.